Good evening, everyone, and my name is Clifton Hickman, and I'm here to discuss the Taco Bell versus Wrench case with all of you today for the Make Your Case assignment. So here's a brief fact summary about this case, which is Wrench LLC plaintiff entered into discussions with Taco Bell, defended over the possible use of plaintiff's Psycho Chihuahua cartoon character. Now, some of the facts about this case is that plaintiffs resided in Grand Rapids, Michigan, who also developed the Psycho Chihuahua in early 1995. Rinks and Shields attended a licensing trade show in New York to Pro One Psycho Chihuahua. Plaintiff marketed Psycho Chihuahua on t-shirts and other merchandise. However, by early 1996, Wrench had licensed the rights to produce the apparel to several large manufacturers. And then for the legal analysis and issues of this case, plaintiff sued defendant for breach of implied in fact contract conversion, misappropriation, and unfair competition. Defendant moved for summary judgment on all claims, arguing that no implied in fact contract was created. It was also preempted by copyright law. Now, the details about the implied in fact contract for this case was that Taco Bell concedes that there was sufficient evidence in the record to support plaintiff's allegation that the parties had a basic understanding that if Taco Bell used the Psycho Chihuahua idea, concept, or image, that Taco Bell would be paid for services rendered. A promise to pay for fair value may be implied even if no agreement was reached as to price, duration, and other terms of the contract. And Taco Bell also argued that plaintiffs cannot prove the existence of an implied in fact contract because the parties did not agree on any of the essential terms that would normally be included in a licensing agreement, such as price, duration, scope of use, and exclusivity. And for the held side, the defendant claims that the essential terms of such an agreement, price, duration, scope of use, and exclusivity. Plaintiff also claimed that those terms are not essential to the creation of an implied in fact contract, but that the understanding that defendant would pay plaintiff for the use of the character was enough. The trial court also ruled that although plaintiff had enough evidence to maintain a breach of implied in fact contract claim, the court therefore granted summary judgment in favor of defendant. Now, for the copyright preemption of this case, the court held that plaintiff's claims met the first prong of the copyright preemption test, meaning it passed the test, and they depended substantially upon the works that was subjected to the copyright protection. Taco Bell also contends that the court should confront the argument and reject the argument. Plaintiff argues that Taco Bell should consider Taco Bell's arguments. And for the discussion, plaintiff appealed that the granted of summary judgment was reversed, and that plaintiff was also rewarded over $30 million of damage from a jury. For the ruling of this case, which is the United States District Court for Western District of Michigan defendant Taco Bell summary judgment upon finding the Copyright Act 17 U.S.C.S. preempted all of plaintiff's claims. Now, for the secondary case, I have chosen a similar case, which was Lapine versus Sandfield in 2011. Now, some of the facts about this case is that plaintiff sued publisher HarperCollins, alleging breach of an implied in fact contract and misappropriation arising out of HarperCollins' publication of a cookbook by Jessica Sandfield. Plaintiff brought a federal act against Jessica Sandfield and HarperCollins, alleging trademark against Jerry Sandfield. The court dismissed plaintiff's defamation against Jerry Sandfield, and Sandfield's remarks on The Late Show with David Letterman and E! News was protected. Now, for the legal analysis and issues of the secondary case, is plaintiff Lipine asserted a number of state law claims against the cookbook defendants, which was again Harper Collins, and also brought a claim of defamation for defamation against defendant Jerry Sandfield. For the pleading, plaintiff didn't claim that a written oral agreement was formed between herself and defendant Harper Collins. Plaintiff's complaint did not contain any factual allegations of conduct by Harper Collins, showing that it was ascended to a contract with plaintiff, and plaintiff's allegations submitted with the proposal that it would be paid reasonable compensation of her ideas. It is on the face to plead a case of an action for breach of implied contract. Now, some of the claims that were made against Sandfield were Sandfield defamed Lipin by making a false and opportunistic claim of plagiarism against Sandfield's wife to deflect attention from the mounting public accusations of plagiarism against his wife. And then plaintiff was angry and historical. Sandfield used his appearance on E! News to outrageously make false statements about Lipin's mental health. Now, some of the claims that were made against Harper Collins were deceptively used Lipin's idea for a book about hiding healthy foods and the foods that kids eat. Plaintiff observed blatant similarities between Sandfield's book and her book. Harper Collins published Deceptively Delicious in October 2007. Now, the outcome of this secondary case is the court dismissed plaintiff's defamation claim against Jerry Sandfield, and Sandfield's remarks on The Late Show with David Letterman and E! News were protected by the First Amendment. And then here are the questions, that I provided for you to answer, which is, were the artist's implied contract claims preempted under the Federal Copyright Act? And then the second question is, when one party requests that another party discloses an idea, knowing that the other party discloses it with an expectation of compensation for the idea's use, is an implied in fact contract created? In other words, was it created? So those are my questions. And then thank you for your time today. And also, here's the slide with all my references.